Hi everyone, I'm your immigration attorney, Anthony Ray. Let's talk immigration. Today we're going to look at what I call the first stage of the family-based green card process, the immigrant petition stage. Generally speaking, the family-based green card process is split into two parts, or two stages. The first stage, which we'll talk about today, is the immigrant petition stage. The second stage has two options depending on where your relative is located. They will either adjust status here in the United States or apply for an immigrant visa outside the United States. We will talk about the second stage in another video. In family-based immigration cases, the government requires that a petition be filed on behalf of the family beneficiary. This immigrant petition can be filed by U.S. citizens or lawful permanent residents for certain family members. The family-based immigrant petition is a request to the USCIS to grant an immigration benefit to the foreign national family member. This process also establishes and confirms the proper legal relationship between the petitioner and the beneficiary or beneficiaries. The filing of the immigrant petition for an alien relative, or Form I-130, does not grant any immigration privileges or immigrant status. Therefore, family members in the United States, whether legally, overstay status, or illegally, the filing of the immigrant petition does not directly change or impact the current immigration status. If the family beneficiary is outside the United States, the filing or approval of an immigrant petition will not impact their status because one does not and cannot hold the status outside the United States. As always, with our immigration legal system, there are exceptions. For the exceptions, you really need to speak with an immigration attorney to analyze what the exceptions are and to see if they really apply to your case. Please note that filing or obtaining an approved immigrant petition may impact the family beneficiary's ability to obtain other immigration benefits. If you are a U.S. citizen, you can file an immigrant petition for your parents, spouse, children, and siblings. If you are a lawful permanent resident or a green card holder, you can file an immigrant petition for your spouse, minor children, and unmarried adult children. There are always a lot of twists and turns in immigration, such as the death of the petitioner, stepchildren, and the consequences of criminal history. So check with us before you start the process to make sure you're on the right path. For most family-based petitions, there is a quota or a limitation on the number of immigrant visas or green cards issued each year. In order to keep everyone in line, one's priority date is very important. The family beneficiary's priority date is established or set when the immigrant petition is filed with the USCIS. You can check the progress and status of your priority date on the Visa Bulletin, which is published monthly by the Department of State. The Visa Bulletin provides an idea of how long the family beneficiary might have to wait in order to receive their immigration benefit. Do you have more questions about the family-based green card process? Feel free to contact us with your experiences, problems, and questions. We would love to hear from you and help you if we can. Now, more than ever, it is important that you have an immigration attorney involved in your immigration case to navigate the ever-changing immigration landscape. Get the Ray Law Advantage. Get the information and knowledge you need to have peace of mind. Until next time, stay on the right immigration path. Thanks for watching. Bye for now.